Benjamin Franklin said, "They who would give up essential liberty for temporary security deserve neither liberty or security." With the promise of keeping us safe from gun violence, violent extremists, and domestic terrorists, Congress wants you to give up your essential liberty to be free from unreasonable searches. H.R. 5764 is the first step to a writ of assistance against anyone who buys or sells firearms. This has been done before, so why shouldn't Congress think they can get away with it again? We'll discuss that next on the Constitution Study.
You have to know wherever you make your stand. Came from a long through line of everyday American.
Hello there, everyday Americans, and welcome to the Constitution Study. This is where we read and study the Constitution. We teach the rising generation to be free. I'm glad you could join me. If you want to find out more, please head to the website, constitutionstudy.com. You'll find articles, videos, the podcast. You can find the Scholars website. You can sign up for the newsletter, have these videos sent directly to your inbox. You can even ask a question that I'll answer either in my live Q&A or on my radio program or just to you directly. It's up to you. All of that's there for you to use, and I'll talk a bit more about that at the end of the video. So now let's talk about H.R. 5764 and these writs of assistance. To understand the dangers of H.R. 5764, we need to understand a little bit of our history. One of the most intrusive abuses in the colonial era was the use of writs of assistance. The Free Legal Dictionary defines a writ of assistance as a writ authorizing officers of the British Crown to search any premises for smuggled goods. The idea of a writ of assistance is simple. Government actors would be given legal permission to search your premises for contraband without probable cause. If they found something, then they would fill out the warrant to seize what they have found. As James Otis put it in 1761, "I will to my dying day oppose with all the powers and faculties God has given me, all such instruments of slavery on the one hand and villainy on the other hand as the writ of assistance is. It appears to me the worst instrument of arbitrary power, the most destructive of English liberty, and the fundamental principle of law that ever was found in an English law book." The idea of writs of assistance was so onerous that when the first Congress drafted the amendments that became our Bill of Rights, they specifically prohibited anything like them. The Fourth Amendment clearly states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." The idea behind the Fourth Amendment is quite simple. You have a right to be secure from unreasonable searches. For a warrant to be issued to search your person, houses, papers, or effects, it must be based on probable cause and supported by oath or affirmation. In other words, someone has to go to court and swear or affirm that the information showing probable cause was true. Not only that, but any warrant issued must be specific in where people can search and what they can seize. In other words, the very concept of a writ of assistance is anathema to the rights protected by the Fourth Amendment to the U.S. Constitution. That, however, has not stopped Congress from authorizing writs of assistance in direct violation to their oath of office. Let's start with the Internal Revenue Service Code, Title 18, Section 7602 of the United States Code. Subsection A, authority to summon, etc. For the purpose of ascertaining the correctness of any return, making a return where none has been made, determining the liability of any person for any internal revenue tax, or the liability at law or in equity of any transfer or fiduciary of any person in respect to any internal revenue tax, or collecting any such liability, the Secretary is authorized to, 1. The Secretary is authorized, 1. To examine any books, papers, records, or other data which may be relevant or material to such inquiry. 2, to summon the person liable for tax or required to perform the act, or any officer or employee of such person, or any persons having possession, custody, or care of books of accounts containing entries related to the business of the person liable for tax or required to perform the act, or any other person the Secretary may deem proper, to appear before the Secretary at a time and place named in the summons, and to produce such books, papers, records, and other data, and to give such testimony under oath as may be relevant or material to such inquiry, and to take such testimony of the person concerned under oath as may be relevant or material to such inquiry. Whew, quite a list there. Congress passed a law supposing to give the Internal Revenue Service the authority to search your books, papers, records, or other data for the purpose of seeing if you filed your tax returns correctly. That means should you receive an audit notice from the IRS, they are seeking to search your records with an invalid warrant. Now, the Free Legal Dictionary defines a warrant as a written order issued by a judicial officer or other authorized person commanding a law enforcement officer to perform some act incident to the administration of justice. This law also claims to allow the IRS to summon you without probable cause, oath, or affirmation. The purpose of the summons is to take testimony under oath to determine if you have violated the IRS code. In other words, Congress has claimed the power to have the IRS issue invalid warrants, perform unreasonable and illegal searches, and to have you witness against yourself, which could be used against you later in a court of law. Title 18 of the United States Code, Section 7602, violates both the Fourth and Fifth Amendments to the U.S. Constitution in only one paragraph. Yet each year, thousands of Americans voluntarily submit to these illegal searches for fear of what the almighty IRS would do to them if they do not comply. And this is only the beginning. Title 31, Section 5313 of the United States Code reads, when a domestic financial institution involved in a transaction for the payment, receipt, or transfer of United States coins or currency or other monetary instruments the Secretary of the Treasury prescribes, in an amount, denomination, or amount and denomination, or under circumstances the Secretary prescribed by regulation, the institution and any other participant in the transaction the Secretary may prescribe shall file a report on the transaction at the time and in the way the Secretary prescribes. A participant acting for other persons shall make the report as the agent or bailee of the person and identify the person for whom the transaction is being made. This little piece of tyranny basically says the Secretary of the Treasury gets to tell banks and other financial or trading businesses to collect and report whatever information the Secretary may prescribe by regulation without probable cause. If you watch crime dramas, you've probably heard that banks are required to submit a suspicious activity report, or an SAR, to the government for every transaction of $10,000 or more. One of the things Congress tried to do was lower that threshold to just $600. While that attempt was defeated, the constitutional violation still exists. This law assumes that any transaction of $10,000 or more is not only suspicious, but probable cause that a crime may have been committed. I don't know if you've noticed, but the price of a car, a home, a motorcycle, land, and many other perfectly legitimate transactions are greater than $10,000. So the claim that any transaction of $10,000 or more is probable cause of a crime is offensive, ludicrous, and yet another violation of the oath of office every member of Congress took before assuming that office. And should you wish to comply with this law by conducting transactions in smaller amounts than need to be reported, you are charged with structuring transactions. So even if your transaction was perfectly legal, Congress considers it a crime to hide it from the federal government. Now with H.R. 5764, Congress wants to use the same writ of assistance technique to track firearm transactions. In general, no later than 1 year after the date of enactment of this act, FinCEN shall request information from financial institutions for the purpose of developing an advisory about the identification or reporting of suspicious activity relating to A, how homegrown violent extremists and perpetrators of domestic terrorism procure firearms and firearm accessories for the purpose of carrying out lone actor or lone wolf acts of terror within the United States, and B, the ways in which the firearms market in the United States is exploited to facilitate gun violence in the United States. This legislation doesn't demand reporting of transactions yet, but it is the first step toward doing so. It appears Congress wants to expand the definition of suspicious activities for financial institutions to report on, including what they think homegrown violent extremists and perpetrators of domestic terrorism might do to acquire firearms. The question that never seems to be asked in the legislation like this is, what makes a transaction suspicious, and what makes these transactions probable cause that a crime has been committed? For example, you may think buying 10,000 rounds of ammunition is suspicious. However, everyone from competitive shooters to people who are just looking for a bargain or just concerned about shortages may see this as a reasonable act to take. And if someone finds 10,000 rounds suspicious, what about 1,000 rounds or 100 or just 10? One day I was at a gun store and they had nice older rifles for sale. So I bought two, one for me and one for my father. Now, some people may see a person purchasing two rifles at the same time suspicious. Well, I was thinking it would be nice for my father and I to have identical rifles with consecutive serial numbers. And let's face it, if someone is planning to perpetrate some form of domestic terrorism, they're either going to buy their weapons on the black market or make sure their transactions are squeaky clean to avoid attracting attention. So the only real outcome of this attempt to develop a reporting system for suspicious activities related to firearms is further erosion of our right to be secure from unreasonable searches and potentially create another illegal federal firearm registry. Now, some of you may be thinking that if people don't have anything to hide, why are they worried about those in government checking their actions? While you may have nothing to hide, you do have everything to protect. As Benjamin Franklin said, if you are willing to give up essential liberties for the promise of temporary safety, you deserve neither. If you are willing to give up your right to be secure against unreasonable searches and seizures for either of these reasons, who will protect your rights when someone else comes up with an even more invasive reason? You may think it's reasonable for the government to poke around in your financial records to make sure you paid your taxes correctly. But what about making sure you pay your mortgage and credit cards on time? You may find a $10,000 transaction suspicious until you need to borrow money from a friend. And sure, you may think that your neighbor purchasing firearms and ammo are suspicious until the day the mob shows up and the only one who has the tools to protect you is that neighbor. The question shouldn't be whether someone thinks something is suspicious, but what are the requirements before government can go snooping around your stuff? Those in government claim that these laws are necessary to keep the people safe. Well, as William Pitt the Younger said, necessity is the plea for every infringement of human freedom. It is the argument of tyrants. It is the creed of slaves. The Constitution requires there be probable cause before you or your stuff can be searched. Not what a government bureaucrat thinks is suspicious or what your neighbor thinks is suspicious. The Constitution also requires that said probable cause be supported by oath or affirmation before a warrant is issued. Not legislation that demands you show people your books or that you show up and witness against yourself. Yet today, the government in Washington, D.C. has claimed the power to issue these writs of assistance, and we the people have given up our right to be secure against unreasonable searches in exchange for the promise that government will keep us safe. Because Mr. Franklin was right. The American people deserve neither liberty nor safety, and we will not deserve them again until we refuse to give up our rights every time someone in government claims it's to keep us safe or it's for our own good. Whether you call it the camel's nose under the tent or the slippery slope, this is just another step, a first step in another attempt to deprive you of your right to be secure from unreasonable searches. Just because some government bureaucrat or legislator says it's necessary doesn't make it legal. And because we the people have rolled over to get our bellies rubbed by the federal government so often, we're ready to roll over and do it again. Whether it's the IRS, the $10,000 transaction, or now firearms, these are all excuses for the government to invade your privacy, to search your stuff without good reason, without probable cause. And every time we let it happen, they get bolder and bolder and bolder. How long before the government merely shows up and says, hey, we need to search your medical records to see if you've been vaccinated? Or, hey, we need to search your refrigerator to see if you got junk food in it? How long? This is what happens when we the people stop defending our rights. Now, I'm still doing my Knowing Your Rights tour, and I'm looking for more dates. So if you want to find out more about the tour, and especially if you would like me to come speak to your group, go to constitutionstudy.com/tour. You can find all about the event. You can find any new locations that I add, but at the bottom there's a form that you can request me to come speak to your group. I'm speaking to groups all over the country, and I'm looking for more. So please check that out. Also, I'm going to do an online Constitution study next year. I'm still putting together some of the details, but you can pre-register. Just go to constitutionstudy.com/study. You get to help choose the day and the time of the week that I will be doing these events. I'm still working, like I said, still working on the schedule, but it'll be out there. Founding Father John Jay said every member of the state ought to diligently read and study the Constitution of his country and teach the rising generation to be free. And there are a lot of resources on the Constitution study that'll help. But I've set up another site called Constitution Scholars, and it's there for people who really want to study. They want to go deeper. Now, it's absolutely free to join. You do have to register, but it's free. You get access to some online libraries. You get access to some online classes. Most importantly, there are community groups. Right now, I got groups for each and every state, and I'm setting up more for different topics people want to talk about. But it's a place for you to go and share information, to ask questions, to interact, hey, maybe even conduct your own study. That's there for you to try, and there's other ways that you can go farther. Just check out more on constitutionscholars.com. But most of all, regardless of how you go about studying, I recommend that we all take some time and take a look at what's going on in your county. I talk a lot about Washington and occasionally what's going on in some of the states, but we really need to get control of our counties. If 2021 has shown us anything, our school boards are out of control. And that's a great place that you can start. If you have constitutional people on your school board, as your sheriff, as your county commissioners, well, then they can defend your rights while we're working to save our states and the nation. So try all that, check that out. Most of all, be engaged, ask questions, be involved. Hopefully you've learned something from this little discussion, and hopefully you found something worth participating in, which means I hope I'll see you here next time for the Constitution Study.